All right, well, good evening, everybody. My name is Sam Osborne. I'm the Education Coordinator for SCA Victoria, and it is an absolute pleasure to have all of you here tonight for committee training for committee members. Tonight is a 3-hour webinar, and it is completely free, and we run these about 4 times a year for the general public, people living in owners corporations, and we would love you to share this link. If you ever want your other committee members to be coming along to this, please invite them. Now, tonight we have 2 very experienced trainers. We have Carol Anderson. She is from Lighthouse Consulting and Training. She is a very experienced strata manager, and I often like to say that what Carol doesn't know about strata has not yet been invented, and she is an excellent trainer, and we are very lucky to have her here tonight. And also Rochelle Castro, she's the director for RC and Co Lawyers. Carol and Rochelle, good afternoon.
Hi, Sam. Hi, everyone.
And if you'd like to turn your cameras on, make this as in person as we possibly can. We'd love to see your smiles. We encourage people to participate, ask questions. Tonight is being recorded, and you will get a copy of this emailed to you probably in the next few days, along with the document pack that is part of tonight's training. All right, Carol, over to you.
Fantastic. Thanks, Sam, and welcome, everybody. Normally, we would have Julie McLean with us tonight. Unfortunately, Julie is not well, and she has almost lost her voice. So Rochelle and I will go through the training with you tonight. I've just gone to the wrong space. We have a poll that we would like to do first, just so that we can see where our audience is from. Sam, if you could do that.
Poll is launched, Carol, and people can go ahead and start that.
Okay, so we've got some newbies by the look of it, less than 1 year, 25%. So welcome to those people. The new year, a first year on a committee is always a bit overwhelming, can be intimidating if you have not any business experience, because that basically what you are doing is managing the business of your owners corporation on behalf of all of your members. Year 1 to 3 years, we've got 24%. So these people by now will have some excellent skills and knowledge about their owners corporations and how where the funding goes, how the business of the owners corporation is managed, how they interact with their strata manager, and many more things about the maintenance, etc., around the property. And 3+ years, we've got 50% of participants. So that means that you're virtually old hands at this and have got a really good grip on what is required to manage the business of your owners corporation, because it is a business. The tax office sees a owners corporation as a business that has the ability to pay tax and compile GST returns, etc., etc., etc. So we have 44% that have multiple owners corporations. So Rochelle, you're going to have a really good job just going through that with everybody. And 56% which don't have multiple owners corporations, which obviously just have one owners corporation. How many lots? Less than 10, 6%, 10 to 30, 33%, 30 to 50, 22%. So we'll assume that the balance are multiple story, and that, we have 39% with more than 50%. So we've got a good mixture. We've got some small ones, we've got some large ones, and some in the middle there. Thanks, Sam.
There you go.
Format is that we will go through the first part. We'll be on communication and effective communication, roles and responsibilities, and induction for your committee members. Rochelle will then touch on legal basis, rules enforcement, insurance and records. And then Rochelle and I will cover off policy, planning, meetings and finance, which is normally Julie's area. So thanks, Rochelle. If we talk about the purpose of a strata community, we look at it from the point of view of 3 areas. So there is community, there's the management of the assets, and then there's governance, which is the rules and all of the legislation which sits around owners' corporations in various formats. It effectively, you could almost say, is a 4th level of government, the rules and legislation around strata. So community is about the community. How does it operate? How does it want to operate? What does it want to develop and provide for the residents of the community? The management of the assets is very, very important, because the management of the assets leads back to the intrinsic value, both in resale values and rental values when we're talking to investors. The governance, as I said before, is all about the rules and bylaws, and Rochelle will talk more about them a little bit later. Thanks, Rochelle. Okay, so we have this little bit of information here that we would like to share with you, because this is so true within owners' corporations. Managing roles and relationships is more difficult and more important than management of the assets. And in all of the years that I have been in the industry, that is a very true statement, because if you can build trust and respect within the group and develop a really, really strong team relationship, and this may include strata managers, it may include building managers, it may include other stakeholders, contractors that do work for your owner's corporation, that come on site to carry out lift services, essential services, all of these kind of things. It really, really needs to be a team effort to make it work. Otherwise, it is disruptive and difficult for everybody to manage their space in this particular place. Thanks, Rochelle. So we're looking at communicating effectively, roles and responsibility, rules and enforcement. So this is really about community and communication. And I'll just give you something that I came across recently to think about while I'm talking through my presentation on communication. Communication happens on the listener's terms. Every word that is said is filtered through the listener's frame of reference, biases, and preconceived ideas. What remains ultimately is the message the listener understands. Often the message is interpreted with a totally different understanding to what we intended. That so often happens. We know and understand what we are actually saying, but do we know that the people to whom we've delivered the message are actually on the same page. Quite often we don't bother to check, and that leads then to misunderstanding. It actually creates gossip, in fact, because people go off away with their own story. Thanks, Rochelle. So if we look at communication as a facility and thinking about committees, there are many challenges within committees. There's the facility where people feel that they need to conform to the group idea and that they're not available or have the facility to speak about their own ideas. So we encourage managers, and for everyone who's in this training tonight, we actually conduct this same training with strata managers. So they actually know what we are teaching and educating our committees, the information that we are sharing with our committees. So every committee member will bring something different to the table, whether it's through cultural differences or lifestyle experiences, whatever it is, they all bring their own thoughts and feelings. And it's about encouraging consistency within the decision making, that the conversations are held, that the information is put on the table, that there's the ability to build trust and respect within the team so that the team works really smoothly and that everybody has the opportunity to share their thoughts on whatever the subject is. Often there will be people on your committees who are very vocal, and there will be people who are a little shy and will not speak up because the other voices are louder than theirs and they feel that their ideas will not be accepted. If you have a good strata manager, and as committee members yourselves, you can and should encourage everyone in the room to have the freedom to express their opinion before any votes are carried out, to make sure that if these quieter individuals have not spoken up, to just say to them, Jane, I note that you've not participated in this conversation. Could we have your thoughts on this particular subject, please? Just encourage them to speak up so that they do become part of the team and don't go away feeling as though they haven't been heard, because these are the small things that encourage and build trust and respect amongst your committees. Sometimes you may need to ask your strata manager for more clarity on things. The message that you have received may not be clear. You may not have all of the information that you feel you need to make an appropriate decision. So go back to your strata manager and ask them to clarify the situation and make sure that you have all of the information that you need to make good decisions on behalf of your community. You'll have cultural differences maybe on your committee as well, and we need to look at how they will be managed within the team as such. And sometimes decision-making by committees can be a little bit slow. So I always, when I work with committees and I'm requesting a decision, and they have all of the information that they need to have, I always ask for a 2 or 4 day turnaround, because that allows me or your strata manager to be efficient. If committee members do not respond to the strata manager's requests to say yes or no, depending on how your communication operates, whether you have a communication process in place, or does each committee member, each time the strata manager asks something, does each committee member respond direct to the strata manager, or do you have a process in place where everybody has all of the information? The committee, and most committees I know have a WhatsApp group, and they have a conversation externally to the to the strata manager, and the chair of the committee reports back to the strata manager and provides the instructions to the strata manager to schedule the works or do whatever is required for that instruction. That saves the strata manager time, because they've only got to look at one email instead of 6 or 8, depending how many is on your committee. And the strata manager really does not need to know all about the side conversations that go on to get to the ultimate decision. That needs to be held away from your strata manager to keep their inbox clear. So if you haven't got a communication program or policy in place, it could be worthwhile having a look at that, because it will streamline the work as it flows back and forth between your strata managers. You could look at an agreement that when the strata manager sends a request out, that the chairperson responds within 72 hours, so that the workflow keeps flowing and the jobs get done. Because in owners' corporations, where there are lots of maintenance and things to be followed up on, the communication needs to flow freely between the two, and it can't flow if it's being held up at one end. So this is it's a really, really important thing to keep the doors open for communication and to keep the work flowing, because really the committees are the cornerstone of the owners corporation. The manager relies heavily on the committee to make timely and appropriate decisions so that they can administer the tasks for you. So just think about how your current committee might make decisions. How is the information transferred once the decision is made to the strata manager? Do you have timeframes on your communications if your strata manager is asking you to do something? And the same the other way. If you are asking your strata manager a question and you would like an answer, just politely put a time frame on it as well. Could you please get back to me within 72 hours, so that the communication keeps flowing. All of this contributes towards building really good relationships, because your strata manager, if you have a building manager in your building, your strata manager will have potentially a really good relationship with the building manager. And the building manager, in most cases, I know, and this may be something that you may not do at this point in time, but the building managers that I have always worked with have provided a monthly report to the monthly committee meetings of the owners corporation, so that so that then the committee understands what is happening in the building space, And it also, at end of year, generally the building manager will provide an overview for all of the lot owners as to this is what has transpired in my space within your community. So renters moving in and out, any maintenance works, all those kind of things are all covered off in that report. And that's another relationship that needs to be built so that it's encompassed within the circle of communication. And all of these things contribute in and work towards a space where good outcomes can be negotiated for your community. And often if you have a major issue, i.e. maintenance works and programs, that they are really, really difficult projects to slog your way through as a committee member. And the owners have an idea, of what is happening. We'll talk a little bit more about effective ways of communicating with your owners so that the owners actually get the real story and are not making up their own stories, or the gossip vine hasn't gone wild within the building and the committee has to then find a way of managing it. Thanks, Rochelle. So the other side of this coin, and we alluded to this at the beginning, is when communication is unclear, people just go away with their own idea of what they think has happened. And they start to share it with someone else. And the story just goes on and on and on until it escalates out of proportion. And that's when things start to become dysfunctional. When the actual story, the correct story, is not out in the marketplace, and people make assumptions about what they believe it is, and they start sharing these assumptions. So if I go back to what I said in the beginning, make sure when you're in your committee meetings, or that any communication to any of your committee members, it is understood and that they're in the same space as what you are as the deliverer of the message. And it's often okay just to say, we're all good with that. We're in the same space here, just to make sure that everything is understood, because it's very difficult once these grapevines and gossips start within these communities to quell them and give the actual correct version of the story. This means that the whole process becomes disruptive. You don't have a team because the team will be split and be taking sides rather than working together to get an outcome for you as the committee. And just remembering that you literally are the engine room of the owners corporation while you're a committee member. And it's your role, part of your role and responsibility is to manage the funds efficiently of the owners corporation, to manage repairs and maintenance of the building, and to make sure that it's well maintained so that there's no problem areas within the building, and particularly occupational health and safety issues where there might be cracks in concrete, no stair noses on stairwells, or threadbare carpet. All of these issues are risk management issues and need to be attended to by the committee. So effectively, as the slide says, we end up with confusion, tension, and then crisis because we have no team and there's no leaders in the team to bring the team to. Okay, Josh, I'm happy to answer that a little bit later. Thank you very much for your question. And you end up with, it just doesn't function for you. It just doesn't function. And it's hard work. It is hard work being a volunteer committee member in an owners corporation because you have to work with so many different personalities, so many different ideas, thought processes, biases, all of the different things that different individuals bring to the table. Thanks, Rochelle. Okay, so let's look at the types of communication. So we have newsletters, and I don't know whether any of you as owner corporation committee members actually produce a newsletter for your owners. How do you let your owners know what the committee is discussing about what is actually happening within their community? Do you have a quarterly or half year or Christmas newsletter or something that lets them know as owners what the committee is actually dealing with? So if this is not a part of your current process, then it could be worthwhile considering that you either work with your strata manager or you may have someone within your committee who is able to produce this newsletter for you. Because if you ask your strata manager to do it, it is an extra cost. So there would be a cost associated for the owners corporation to produce this newsletter for you. So just check and see whether you've got someone with the appropriate skills in your committee that could do this for you. Community portal, this is one of the areas, thanks, Darren. This is one of the areas that I use as a really, really great tool within the communities that I work with. The properties that I work with are all, I call it my hospital portfolio because I only work with a small amount of properties now because I am working with those committees to help them work through difficult circumstances with all of them. And I have encouraged all owners within these 5 communities to get themselves onto their community portal, because I might send daily messages or weekly messages through the community portal, because these owners corporations have major works projects happening. If they haven't got major works projects happening right now, they're working towards major works projects. And so the community portal, even in the case of, I recently, and I'll just give you an example, I recently had one of the communities had a problem with their community TV aerial. And it got to the stage where quite a number of members within the community had no TV reception. The committee were focusing on a very major works project and really didn't have time to attend to this. So we put a note out on the portal saying, yes, we are aware of it. We will endeavour to get it rectified as quickly as we can. One of our owners actually put his hand up and said, hey, I work in this area, I can help. And it was absolutely fantastic. We had them back on to their TVs and their evening favourite shows and their glass of wine by the end of that week. It was just amazing that just a simple message on the portal brought us a new resource. It was absolutely fantastic. And everyone within the community was really, really grateful. So they're the kinds of things that can be achieved. SMS for emergencies. Encourage your strata manager to maybe set up an SMS for emergencies, i.e., if you have a multi-story building and it has one garage door in and out of the community. If the garage door breaks down at 5 a.m. in the morning when the building manager's not on site, and an owner reports it, then you would be, the strata manager can actually send a message to everyone saying, garage door is broken. We cannot open it manually, unfortunately. Therefore, everybody, please note, you may have to find another way to get your children to school today. If you have a medical appointment or an appointment external to the building where you would normally use your car, please arrange another form of transport. The gate people have been called. They will be at the property between 9 and 11 a.m. We will advise you when the gate is repaired. That way, then the owner's corporation, when the owner's corporation manager gets the message, they don't get 70 or 80 phone calls from angry, emotional people jumping up and down, because there's a plan in place and people have time to make other arrangements to get themselves out of the building during this time. So think about all of these ways in which you can potentially look at and improve the communication just within your own group. Social media is another space which you can use. However, I say that with a warning. If you are going to use social media within your group, please make sure you have a very strong administrator in place to make sure that any information that should not make it to the public does not make it to the public. I have seen instances where social media pages had to be closed down because effectively they became a slanging space between owners. So if you are going to go down that path and have social media within your groups, please make sure there is strong administration of that space. Emails and phone calls, we use those every single day. They're part and parcel of our world now. And it might be worthwhile every now and again to conduct a survey of your owners, just to find out what their thoughts and feelings are about how the community is functioning. It's a good way to get feedback. Some of the feedback will be ugly. Other feedback might be very, very constructive. But you just take on board what comes back, look at it, and say, well, yes, we could do this and this, but we can't do this. And so it gives you an idea of what your community is thinking about and what sort of things it might want the committee to deal with outside of the normal day-to-day committee. Okay, I'll answer that a little later, Darren, as well. If the, it's a matter of making sure that the individuals within the community are across what is happening, because in years gone by, when I first joined this industry, it was all about the managers having all of the information and not sharing anything with their committees and the lot owners. And that's a really difficult space to be in, because if you don't know what you don't know, it's impossible to make good decisions. So that's one of the reasons that we have implemented these committee training programs, so that we can help committees make really good decisions and work out if their managers is the right manager in the right space, or whether they need to move on, or what they need to do. So these are all things that the committee has to take on board and has to think about. Thanks, Rochelle. So if we're looking at roles and responsibilities here, there's a lot of them. It's a very busy space. So initially, there's the architect, the builder, and the surveyor, if it's a new building that has to be dealt with. Now, in circumstances, sometimes the builder or developer may have a I'll call it a relationship with an owners corporation management company, and they may, from day one of the building, before they even put the first peg in the ground, so to speak, work with the strata manager to look at the design of the building, what facilities are in the building, how they're best accessed, all of that. Because the strata managers have a wealth of knowledge in the functionality of buildings. An architect designs a building so that it will look fantastic. It's not necessarily about usability when the architect designs the building. The builder builds what the architect designs, and in the middle of that, the surveyor will look at the design, work out the lot entitlement and lot liability for the plan of subdivision. So all of that happens before the owners corporation comes on board. And it's only when the owners corporation is registered with the Land Titles Act that it becomes an entity. Until that time, it's just a PS, a plan of subdivision number. The owners corporation is not an entity until the plan is registered with the Land Titles Office. And once the plan is registered, the certificate of occupancies have usually been issued around that time. The inaugural meeting takes place. Now, to get to that point, there's a lot of things that need to happen, that have to happen before it gets to the first lot of owners moving in. If there's embedded networks, there are contracts in place. If there needs to be a building manager, the building manager needs to be in place so that the owners can move in when the time comes for them to move in. In smaller properties, these things will not apply, but in the bit larger properties, for committees that are part of larger properties, you will find that there are probably anything up to 6 contracts in place when you get elected to the committee. There might be essential services, there might be lift contracts, if there's embedded network and hot water contracts. All of these have to be put in place so the certificate of occupancy for the building can be issued. So there's an assumption that the strata manager or that there's been kickbacks and all of that kind of thing. And that is not necessarily so, because if these contracts are not in place prior on a new building, prior to the people moving, the residents who've bought or renters who are living in an investment property, then these services can't be provided to the owners. The contracts are all signed prior to the certificate of occupancy being So a good committee will look at those contracts within the first 12 months. So if you're in a brand new OC and you haven't yet or don't have a list of all of the contracts that are in place in your owner's corporation, ask your strata manager to provide you with a list of those contracts and the dates they are due to expire. You will find that some of them are 3-year contracts because there is a service component in it. But you at the committee need to review all these contracts, decide whether they are appropriate, and if they want to take them to market, take them to market to test the market to see whether these contracts are appropriate in the space that they're being used in. So then we get down to, once we've dealt with all that, we come to our owners corporation managers and the building facility manager, the tradespeople and the real estate agent. That's part of the circle. Then we have the OC managers who deal with the committee and the owner occupiers. The committee are the decision makers. Your strata manager is there to administer the business of the strata community. They are not there to make decisions on your behalf. That's the committee's job. If you want more information or if you need to talk to an expert in whatever space you're working in, then you need to ask your strata manager to help you find those experts to talk to so that you have the appropriate information to make good decisions. We also, and the juggle is the owner occupiers and the investors. They have different ideas about their wants and their needs. So the owner occupiers want the building to be always schmick and up to space, and the investors quite often reluctantly pay their fees. So you're dealing with two different mindsets as well. So it's all of these people in these roles that make it so complex. And how do we as a team make this all work? Thanks, Rochelle. Okay, so committee induction here. The first meeting of your year, and as a committee, if you are in that space, you should, even for smaller OCs of 13 and above, which it's mandatory for them to have a committee, you should have at least 2 committee meetings a year. For your larger ones, you might have monthly committee meetings if there's a lot going on. You might have bi-monthly committee meetings, but you should have at least 2 meetings a year if you're in a smaller OC up to 20 or 30 lots. You need to, straight after your annual general meeting, hold a meeting to look at what you're going to cover off within the next 12 months. You should also have a budget and finance meeting prior to your budget being set for the next year, so that you as committee members can see, what have we spent money on this year? Have we been in have we overspent? Has there been works that there was no contingency to cover and we've had to raise special levies? So, you know, it's really, really important that as committee members, you understand those things. You can agree on a team agreement for your committee. You can have a code of conduct for your committee. You can also have a conflict of interest policy. When I conduct my committee meetings, about the 3rd item on my agenda is for all of my committee members in attendance to declare any conflicts of interest with any items that are on that meeting agenda, so that I've got it up front and the balance of the committee can then decide how they want to manage that conflict of interest. In an induction pack, there is an example of an induction pack in the documents that you will receive from this training tonight. This is a good way to get your new committee members up to speed quickly. Anyone who has just been elected to a committee and has attended the first committee meeting will be thinking, what is going on here? I have no background. I don't understand what on earth is happening here. So if you have an induction pack that has maybe the last 12 months committee meeting minutes included in it, it has contractors, it has a copy of the contract of appointment with the owner's corporation manager, it has a list of all the contracts that are in place. All of this information, when you give it to a new committee member, they can go away. You've got a list of your committee meetings, i.e. we're going to meet on the third Monday of every month. And you should set those dates for your committee meetings at the first committee meeting you have after your annual general meeting. Because the notice period for a committee meeting under the legislation is 3 business days. Now, I don't know about you, but I know that if someone gave me a notice with a whole heap of paperwork, including quotes and scopes of works and all of the other things that we sometimes have to deal with, and said we're meeting in 3 business days to discuss this, I would not have time to even be prepared. So encourage your strata manager to get your documents out to you at least 7 to 10 business days prior to your committee meeting, so that you have time to read the documentation. And when you go to the committee meeting, you are there to effectively discuss the situation and make a decision, so that the decision is made at that meeting and doesn't drag out for weeks and weeks and weeks because everybody's not across the information. This is another way to streamline your business. You also will find some templates of policies within your pack that you will receive. Things like debt collection policies. You can put these in place. It helps your owner's corporation manager manage your debt collection process because they know exactly what to do. Well, if it's at this point, this is what we do. If it's at this point, then we send it off for debt collection and we advise the owner that it's gone to debt collection and they will now be responsible for all the associated fees and charges. So you can have procurement policies which give a space for you to make decisions in when you're seeking quotes, parameters. You know, I would, in this day and age and with the traffic in Melbourne, I personally would not seek a quote for work that was less than $1,000. Because I am asking a tradesperson to potentially travel 2 hours through traffic to get to the property. Then I ask him to give me a quote. I might be asking another tradesperson to do exactly the same thing. The tradie goes home. He puts a quote together. There's $23 difference between his quote and the other quote. And the committee always opts for the cheapest quote, regardless of what the work scope might say. That's the experience we find at our end of the dam. So you've already burnt one contractor. When we call him the next time and ask him to do something at your property, he will say no. So you need to be mindful of these things, that they've got to travel 2 hours to get there. They've got to spend an hour putting the quote together, and they don't get the work. They have given up 3 hours of their time for $1,000 job. It just doesn't make any sense for them. So think carefully about when you are asking for quotes. I always encourage my committees that if I'm not sure of what the job is and I'm asking a tradesperson to go, when I speak with the tradesperson, I will say, please take your tools with you. I don't know exactly what this job is. Ring me from the site. Tell me how much you estimate this job to be, and I will say, yes, go ahead, or no, don't go ahead. Please provide me with a quote. So you need to be looking at these methodologies for efficiencies and streamlining how you action the business of the owners corporation. Yes, Darren.
I thought I'd be interactive.
Fantastic.
Magnificent. Thank you, Darren.
The one observation I would make with that $1,000 quote or whatever is a lot of the issues that we've in the past got quotes for can actually be resolved at a committee level. For an example is gym equipment. We had a cable get stuck on our gym equipment. They wanted the OC manager wanted to send out a tradie at $500 and it was going to be approved. I said, look, can someone just go and have a look at it? It was 1 second fix, and it was and I was able to fix it pretty quickly.
Fantastic. That's
so
excellent.
I think the observation I would make is we've also got to consider as OC committee members, is it something that we can fix ourselves as well?
Yes, I absolutely agree. If you have the skills to be fixing it, that you go ahead and do it. However, if you don't have the skills, it's not an area that I would be meddling in, because you may
exactly.
create,
I understand that. I understand that, but I guess that's where it's being, showing a bit of diligence and, simple things like, oh, the door won't shut. And you go and say, well, the reason why the door won't shut is someone's messed around with it or has left it locked. So sometimes it's being sensible with the way we send out our trades as well.
I absolutely agree with you 100%, Darren. It is, due diligence. Thanks, Rochelle. Okay, so this is the kind of information that will be in your induction pack. So information the committee members need to know about their strata properties. So a little bit of history, the minutes for the past 12 months so that they can read them, some reading for them so that they can get themselves up to speed with where the committee is at, because that will help you if they come on board as a proactive member straight away. The legal structures and how they operate within committees and etc., or even within the owners corporation, because there is quite a lot of legislation around owners corporation in rules and regulations and do's and don'ts, etc. The roles and responsibilities within the committees. You may have finance subcommittees, you may have working parties, green working parties, you may have garden groups, you may have all of these kind of things. As I suggested, you might develop a code of conduct and conflict of interest policies, committee operations, i.e. how often you meet, what are the dates you meet, and what are the tasks that you have in hand. Encourage your strata manager to keep a task list that says, well, Joe's doing this and he's going to have it completed by this day, so that you can keep track of what is happening, particularly if you're working in an older building and you're at a point where maintenance has become a priority within that building. You need to look carefully at your budgets and maintenance plans and understand what is in front of you, and do you have appropriate funds to carry out those works in a timely manner. Building and administration operations, well, the strata manager generally is elected the secretary of the owners corporation and would carry out all of the admin tasks for you. If there is a building manager in place, as I said before, it's good to get to know the building manager and build a strong relationship with them along with your strata manager as well, because they can help in the management of your building and your assets. External stakeholder management, we talked about contractors, etc. at the beginning. So thanks, Rochelle. So these are some of the things that your strata manager does not do. We don't create the rules. Generally, what happens here in Victoria, there are a set of model rules which the government and Consumer Affairs have developed. These model rules apply to every owners corporation in Victoria, even if there is a set of registered rules. The model rules will sit beside the registered rules. If you do not have registered rules and you're asking your strata manager to breach people's behaviour, etc., then the strata manager cannot do it. If their registered rules are not registered, then they have no power to be enforced. So if you have extra rules that you might call house rules or what, just call them community rules, then unless they are registered, they have no power. So it is not appropriate to be asking your strata manager to issue breach notices when those rules are not registered. We do not dictate the actions of the owners. We often have neighbours or people within the same living space send us or ring us up or send us emails complaining about the individual next door to them or the person up the corridor. That is not the owners corporation manager's role. There is a dispute process in place which needs to be activated in these circumstances. And that dispute process requires that these individuals must speak to one another in an endeavour to resolve whatever the problem is between them. I have been to VCAT a couple of times within owner disputes where the owners would not speak to one another, yet one of them had taken the matter to VCAT, and the VCAT member just said to the two owners, have you two individuals spoken to one another in an endeavour to resolve this matter? The answer was no, of course. So therefore, the VCAT member just said to them, there is a meeting room outside. Please go out there. You've got 30 minutes to resolve your issue. Owners corporation managers, and this is a very difficult space and becoming more and more relevant within buildings, is manage mental health. We are not mental health experts. Owners and residents of buildings are not mental health experts either. I would suggest that the manager actually has the details of the people, the caregivers for these individuals, and that the responsibility for their care remains with the caregivers. I've talked about resolving disputes between residents. Strata manager does not give legal, financial, tax, engineering, or building advice. We're not experts in any of those areas. And if the committees need expert opinions in any of those areas, then they should pay to get that expert advice and not rely on the strata manager to give it, because the strata manager is not qualified to give advice in any of those areas. We do not evict tenants. That goes back to property managers. We do not act as debt collectors. If there is a debt collection in policy in place, we will action that debt collection. And then if our part of the deal doesn't work, well, then we would hand it over for debt collection. And the owners' corporations, dissimilar to property managers, does not have a requirement to inspect buildings. Some owners' corporation managers do. However, we are not experts in buildings, and I would always quantify any visit I made to a property by saying it was a visual inspection only, because I can't write up a report on a cracked footpath or work out how it needs to be repaired. Thanks, Rochelle. So we have now reached the end of my section, and Rochelle is going to take over shortly. This is just a little bit about SCA. SCA have a respect pledge in place, and the majority of members that belong to SCA and committees and owners and their suppliers can join in with this and just take the respect pledge. It's all about endeavouring to encourage harmonious living, respect, and willingness to come together within your community. There is a website there, so if your community is interested in becoming involved and taking this pledge, then we encourage you to do so. Thanks, Rochelle. So we've got 3 questions here, and we've pretty much answered them all along the way. So poor communication, we understand that it leads to confusion, tension, and ultimately you end up with a crisis on your hands. Open, transparent leadership, publishing committee minutes on portals, newsletters or regular updates, SMSs in emergencies, etc., etc. We've shared quite a few ideas for you. Who are the elected office bearers? Here in Victoria, it's mandatory to have a chairperson, even in your smaller OC groups where you have less than the 13 members required for an official committee to be elected. There must be a representative who will act as the intermediary with the owners corporation manager. So smaller OCs, please be mindful of that. We often have everybody sitting around the table and nobody putting their hand up. It's not a difficult job. It is just to interact with the owners corporation manager so that all works and any activities that need to be activated can be done so in a timely manner. Generally, you will find here in Victoria that if there is an individual within the committee of management, that they may appoint a secretary. Often the strata manager becomes the secretary, And if you have an accountant within your group, you may appoint him as your treasurer. However, it's not mandatory to have a treasurer here in Victoria. Mark, I will answer your question and then I will hand over to Rochelle.
Hi, Carol. Can you hear me all right?
I certainly can. Thank
Look,
you.
it's more a statement. An experience I had where we went through about 12 property managers, owners court managers.
Wow.
Be very careful who you choose for your chairperson. The reason I say this is my other property, the chairperson basically stole the owners corporation one roof area. And what that did is that created a lot of dramas. And the problem you had then is he was doing the minutes as well. So you couldn't debate over the minutes. So I would advise you have a separate secretary to the chairperson. And you can certainly validate that by saying if you're a chairperson, you're taking minutes, you're going to miss stuff or you're not part of the whole conversation, so that you can temper that at the meeting.
Absolutely.
And the other problem you have with the chairperson when they do this is that the moment you can't get rid of them, they start making bad financial decisions. If you want to oppose them and take them to VCAT, they use your funds to defend themselves, and they say that their process was done under what they believe to be right. So choose very carefully, and I'd keep the fights until you have the numbers at the next meeting to remove them. That's all.
That's excellent advice. Thank you, Mark.
Yeah.
I don't think we need to comment any further.
No, that's enough. And I did at the very start of the chat, I did put a comment there, a pretty long one, that I wouldn't mind if someone could talk to me about that later. I've got to catch a flight in a few hours, so maybe someone can contact me later.
Rochelle, I will look at all of the stuff in the chat box while you're doing your presentation. How about that?
Great. Yeah, great. And I'm seeing it's fantastic. A lot of comments, a lot of questions, a lot of sharing. So yeah, that's great. Thanks, Carol. I'm taking over now for the second portion out of the 3 in our committee training. And my part is business. I'll cover the third part, half of the third part, which is governance. And then Carol will close off governance, the second half of that, towards the end of our session. Being in a committee, and as Carol has shared earlier, you as the committee, you are the engine of the owners corporation. You are the driving force. You're the decision maker on how the owners corporation will be operating, will be managed for the next 12 to 15 months until the next annual general meeting when a new committee is elected. That's very important. And as a committee, you need to understand that you are running a business. It deals with funds. It deals with dealing with different stakeholders. It deals with the different members, the lot owners of the owners corporation. And that's why this is another important aspect when it comes to being committee members. But as a committee, you must remember that your role is oversight. And to oversee, you must first have an understanding of what you are responsible for in respect of operating and managing the owners corporation. The section that I will be taking you through will cover the different types of strata. You need to have an understanding of that. Compliances, there will be a lot of aspects here. Don't get overwhelmed. Just have a general understanding of what, as a committee, you need to understand when it comes to decision making. Of course, you cannot make decisions if you don't have an understanding of what the owners corporation must manage, must operate. Insurance aspect, risk management aspect, money, and record keeping. So that those will all be part of the business discussion. First one is understanding what are the different types of strata. There are 3 general types of strata. I'd like you to think about your development and determine where it fits. The first type is the subdivision of land. This is usually townhouses or estates, where as a lot owner, you own your lot and everything that is within your lot. And then you've got the common property and the common facilities that's shared. And that's where the owners corporation comes in to deal with the operation of what is shared. The second type of strata is the subdivision of buildings or airspace, usually apartments. This is where an owner owns either some, all, or none of the infrastructure. That's all stated on the plan of subdivision. It really all depends on what your plan of subdivision says. So what does that mean, Rochelle? It means that if your plan of subdivision says You own everything up to the exterior face. That means everything up to the outside of your lot. That is your responsibility as a lot owner. If it's some, usually if it's median, that's up to the midpoint of the structure. If it's none of the infrastructure, that means you see in your plan of subdivision interior face, that means the plaster or the underside of the ceiling. That would be up to the ownership of a lot owner. And everything outside of that, which is the structure, that then all goes to the owner's corporation's responsibility. And then, of course, the usual common property and facilities that's shared. The third type of strata is where the company, it's a company titled, or what others refer to as stratum, company title, and it's through company share, where what is owned is a share in the company, where the company owns the whole of the development, the totality of the development or the building. And as a shareholder, the shareholder has exclusive occupation of a part of the building. So for example, unit 1, as a shareholder entitles a shareholder to exclusively use a particular unit. So why is it important for you to understand the types of strata? To understand the underlying rules and regulations, the relevant legislation that governs these different types of developments, so that you have an understanding when you talk to experts, when you get expert advice, you have a general understanding why one type of strata is different from the other. I get some confusion from some lot owners and shareholders who mix up the concept of that if it's a company title, you can apply the Owners Corporation Act, the Owners Corporations Act. That's not the case, although the principles, because it's a strata community, are the same. It is not exactly the same. But that's where you should start off as a committee, understanding the type of strata of your development. Another thing that you need to understand as a committee is if you're impacted by multiple owners corporations. So you see here in the illustration that we have, this is an illustration of a development that is made up of 4 owners corporations, as if each one is considered a separate entity. And you can see here on the left, the illustration, there's an explanation of this development, and that there's different types of owners corporations. You've got the unlimited owners corporation, that's the whole building, and it's usually referred to as owners corporation 1. And then you've got the limited owners corporations. OC2, owners corporation 2, that is made up of the offices. OC3, residential. OC4, the retail lots. And how would you know if you are in a multiple owners corporation? You can see that from your title extract. So the moment you actually signed your contract of sale to buy your lot, you were already informed that you were a member of one or multiple owners corporations, that the lot that you are purchasing is impacted by one or multiple owners corporations. So why does that matter, Rochelle? It matters because you need to understand that if you are in a committee of an unlimited owners corporation, you need to understand that on OC1, Owners Corporation 1, has the right to make decisions to bring legal proceedings or issue legal proceedings, for example, for debt collection, enforcement of rules. That's usually Owners Corporation 1. Owners Corporation 1 also grants lease or license to common property. That impacts Owners Corporation Common Property 1, of course. Contracts and agreements for repair and maintenance of the common property. Holds insurance for the development, for the plan, and usually be responsible for any matters that relate to planning agreements, heritage, and environmental matters. So to the committee, this also means that if you are a member of owners corporation, so let's say it's this development, let's say you're a member, you are a lot owner in this development, and let's say you own an office. That means that you would be a member of Owners Corporation 1 and Owners Corporation 2. And that means you have a right to vote at the AGM of Owners Corporation 1 and Owners Corporation 2. And each Owners Corporation, best practice, and to avoid disputes in the future, should actually operate as separate entities. That's actually best practice. Wherein, what does that mean, Rochelle? It means that each Owners Corporation must hold its separate AGM, or if it's together in the same date and time, at least it's quite clear the segregation of the decisions being made by Owners Corporation 1 members, OC2, OC3, so on and so forth. And of course, if there's separation in that regard about how AGMs are held, it also means that committee members or OC1, that means would have is different from committee members of Owners Corporation 2, OC3. Because each Owners Corporation is making this decision that relates to that particular common property, if you have multiple Owners Corporations. And so keep that in mind and have an understanding if you are impacted by, if your development is impacted by multiple Owners Corporations. Because at the end of the day, really, if it's not properly run, if an Owners Corporation is not properly run, that it should be functioning as a multiple Owners Corporation, it starts when someone is asking, why did Owners Corporation 2 pay for common property 3 expenses? And I'm not a member, and that's where it usually, based on my observation and disputes, and to avoid all that, you as a committee, you need to get an understanding, and also where necessary, get guidance from experts about how multiple Owners Corporations should be operating. And you're likely to look back into your documents to see if you are impacted by, or if there's improvements that need to be made in the operation of your multiple Owners Corporations. Another theme that you need to understand are the 2 key things here in this pyramid. So we've got on the left side, legislative framework, the different levels of laws that the Owners Corporation is guided by, or governed by, not guided, governed by. And then of course, the different types of documents, hierarchy of governing documents that we see. We do encourage you to investigate what you have in respect of the documents, but let's go back to the legislative framework. So different levels. Federal is everyone in Australia who are residents are impacted by federal laws. An example of that is the Corporations Act. So if your company title, if your development is a company title, that is a federal law. A state law is an example, and a state-specific law is, for example, the Owners Corporations Act that only applies to Victoria, and that specifically impacts those who are members of Owners Corporations. That's another level of the legislative framework. Of course, you have local laws. If some of you, if your development is located in city of Melbourne, you would have different schemes. If you are impacted, for example, with heritage laws, it would be different if your development is located, let's say, in the northern suburbs of Victoria. And also there's different types of OC hierarchy, and that's when we go to the governing documents. So if you look here in the pyramid in respect of documents, it's important that you as a committee need to understand that the plan of subdivision is on the very top. It governs really how an Owners Corporation and the way they make decisions should be guided by the plan of subdivision or the strata plan. It says who owns what, who should pay for what. It identifies what is private property. It identifies what is common property. And that's when you make a decision. Let's say you have a strata manager who comes to you and says, there's a burst pipe that needs to be rectified. It's been reported by a resident. And you, as a committee, you go back to the plan of subdivision, identify if it's common or private, and all other aspects. There's other aspects as well, such as where is the source of the problem, who caused that problem, and all those other aspects. And again, I have to always say this, because Carol also said this, where necessary that you identify, especially if it's complex, to get expert advice when you need to determine certain complex issues. And so it's important for you to refer, that's my point. My point is understand that's at the very top. The plan of subdivision governs the responsibility of the Owners Corporation, versus the responsibility of a lot owner. Underneath that are the agreements. That means particularly, I want to focus on lease licenses and other agreements. That's under the plan of subdivision, because then it dictates, for example, identifying if that whether the owners corporation has a right to decide if a certain part of common property, if it's common property, could be leased or licensed to a third party. Underneath that, Carol already touched on this. If you have registered rules, meaning created and passed at the beginning, and if you don't have, if your development does not have one, model rules. But that's in accordance again and governed by lease and license and agreements, and also the plan of subdivision. And you can see there I want to emphasize this, particularly committee resolutions, policies, and procedures that you make as a committee, and even owners' decisions. Owners' decisions is usually in general meetings or ballots that's issued to all lot owners. Just because a resolution is passed by your committee, it does not mean, and it's not in accordance with the plan of subdivision. For example, I'll give you an example. Let's say it's been if the plan of subdivision confirms that the front landscape, and let's say it's a shared driveway, a small scheme development, and the driveway is common property, but there's one lot that is on the street. The rest of the lots are behind that particular unit. So it appears as though the front landscape is only enjoyed by that one lot that is on the street. And so for example, this particular committee passed a resolution that it will require that lot that is by the street to be the one responsible to pay for that common garden, which is definitely against what the plan of subdivision says, because the plan of subdivision confirms that that's common property. And the Owners Corporations Act requires that the Owners Corporation is the one responsible to repair and maintain common property. Josh has a question. Yes, Josh.
Yeah, I just had a question here with specifically like when there's a clash between the different responsibilities here. In one specific example there, say the plan of subdivision requires that share cars be placed on the common property, but then the OC regulation says that you cannot lease common property without passing a special resolution. And then obviously passing a special resolution is typically very difficult. And so you are left in a spot, well, do you break the OC legislation and enter a lease without a special resolution? Or do you break strata planning regulation, like the planning permit, and then risk having a fine there? So like,
yes,
yeah, when they conflict, how do you deal with that?
Good. Very good question. We go back to the legislative framework of what does the law say. The law says you're exactly correct. Special resolution, 75%. Interim, I'll make it a bit complex. Interim 50%, and if after 29 days no one disputes, that becomes a special resolution. It's okay with a 10 lot development, but if you have a 400 lot development, that's very difficult to achieve.
Yeah, we've tried. Like in our case, for example, we've tried 3 special resolutions. None of them have met the requirement. So like, but so then the case there is that there is still this clash. Then so
yep, cannot. The Owners Corporation is not capable, and that definitely means the committee. The committee can only make decisions that require ordinary resolutions, meaning you don't need to check with the rest of the owners, and that is not one of them.
And so
leasing or licensing common property. And so that leaves all lot owners who want this lease or license to happen to work hard to get that. That's pretty much what they say in VCAT. That's what they say in courts, and that's what the law requires. Special resolution, that's what must be achieved. In the risk of that, what is being risked by the committee if they push and just say, oh well, we didn't, let's just proceed with the lease or license. There may be one lot owner, and I've seen it, who is more than willing to get a judgment, run to VCAT or the courts and get a judgment and say, I would like the committee to cease allowing a particular person to use part of the common property because they do not have a valid lease or license. The rationale of that is that the special resolution, and I'm summarizing case law, A special resolution is required to get 75% of the owners to say yes, because it is technically depriving the rest of the owners from enjoying that particular part of the common property. The purpose of the common property is for everyone who's entitled to use it to enjoy it. And that's why the hurdle is so high when it comes to granting a lease or license of the common property, because technically you're depriving everyone else from using that space. So what a guidance we give is work hard to get the votes in, to get the lease or license to become valid. So the special resolution is definitely key and actually the heart of making a lease or license valid. And that's the reason why, see, the resolutions of the committee is at the bottom, because it must be in accordance with the rest of the governing documents. And you've just actually addressed the right situation. That just demonstrates why it's important to have at least a general understanding by the committee. You're not expected to know the laws. That's where you bring in the experts. You're not expected to know details
I guess in our case, and I know dealing with specifics, and I know everyone there was, but in our case, like we were facing possibly a $237,000 fine for breaching that. So then, is there like a pros and cons of like $237,000 fine is significant versus the lease agreement? Like, do you think that?
If the owners corporation is fine, that means if the committee makes a decision that is that adverse, that will impact and cause the owners corporation to be fined, that actually means that the committee is making a decision that impacts each and every single lot owner.
But that's not, but like you said, it's not a decision the committee can make because it's a special resolution only.
Yes, exactly. And so do tread with care. And I'm glad Josh also addressed that. You know, I did say in this portion of the slides that, you know, the committee can make decisions. You know, you've got actually significant powers. You can make powers up to, let's say your budget for the year at the last AGM is 100,000, for example. You actually have a power to raise a special levy up to $200,000 for a special levy. You do have that power because it doesn't require special resolution. Anything over more than twice the annual budget, that's when you need to go back to all the lot owners and get that special resolution. That's I'm referring to funding. But that doesn't mean that you should be making that decision. If you as a committee decide that no, that this is too significant for us to ask them for a special levy once off, but it's more than twice what they should be paying for a year, it's better that we call a general meeting and have a conversation with the rest of the lot owners. You can make that call. So just because you've got that power doesn't mean you should be exercising it. And this is where you as a committee need to really consider that, and it's important where you make decisions, it does impact all the lot owners. And there is that obligation for the committee that the decisions that it makes should be for the benefit, for the interest of everyone else, and it shouldn't be for the interest of the individual committee members. I will also, well, let's move to a table. So we do encourage that you create a table if you don't have one yet. It will help you when your manager discusses issues, repair maintenance issues with you in respect of the regular repair maintenance. This, if you need legal advice on this, do get one. It's a once-off thing, and you could just keep it as one of your key documents so that you can always refer to it when it comes to identifying who should pay for what. It's just an example. So you can see here, you've got the elements on the left column, followed by who should be responsible. What is, will the benefit principle apply? And is it an insurable item? So for example, you've got here the window glass, who's responsible for it according to the plan of subdivision. The plan of subdivision says the glass is a structure and it's part of common property. Is there a benefit for the owners corporation? Will an excess of the insurance apply? Identify that. Could we claim it through insurance? So that you as a committee could actually make a decision in giving instructions to the manager as to whether they should make an insurance claim or not, depending on how much it costs. Darren, you've got a question.
Yes, my favorite topic, windows.
Mm.
So an apartment has a window that's smashed,
Mm.
and the replacement of that window only benefits that lot owner.
Okay.
So why should the OC pay for the for the replacement of the window? I understand that it is owned by the OC, but doesn't the
Yes.
benefit principle apply?
Yeah, this is just a sample. This doesn't
Yeah.
fall under a certain situation. So no, we're not saying that, but this is just an example
Yeah.
where the
Yeah.
owners corporation, yeah, but I understand where you're going with your question. Where the owners corporation would like to demonstrate the benefit principle, it must be prepared in identifying the reasons and it must provide the evidence. And I suggest that before it just gives instructions, the committee gives instructions to the manager to just levy that on the lot owner, have a conversation first with the lot owner based on my experience. And where you as a committee, as an OC, want to say, we're not paying for that, although that's common property, but you caused that. And these are the different evidence, various evidence that actually really support that you should pay for it. We are intending to issue you a levy. You give instructions like that to the manager so that rather than just, head-to-head dispute with the owner. But my point is get sufficient evidence if the benefit principle applies. If it's quite complex, do consider seeking expert advice. And I don't just mean legal advice. I mean expert advice. Let's say if a contractor identifies or could confirm that, because you don't know whether they're going to deny that. It's like, I never broke that. It just happened, just something just happened. But if a contractor could confirm, no, from the way that it's broken, you can see that the impact was from the inside and could not have been caused from the outside, so on and so forth, that could definitely help.
Okay, thank you.
No worries. Yeah, so keep this in mind. It would help you, especially when it comes to unbudgeted items that it's been addressed to you that you need to think about as to whether funds should be spent for something that wasn't planned. Now, administrators, this does happen from time to time. An administrator is not a strata manager. So an administrator comes in where VCAT has been convinced that the owners corporation, particularly the committee, is not capable of making decisions, or the owners corporation is not capable of making decisions. I'll give you an example. An example is, let's say it's a large development, let's say 100 lots. It's a 100 lot development, but for the past 5 years, only 2 to 3 lot owners are showing up in annual general meetings. And then that very same development has been issued with emergency orders. There are cladding issues, and certain areas need to be cordoned off, works need to be carried out, and it's going to cost 4 times the annual budget. Clearly, decisions like that, the committee would just be very stressed, understandably, and they would need to be considering having a sit-down discussion with lot owners who they know will not take it lightly. And let's say this committee has issued a lot of notices, has called a few information sessions, has even called a couple of ballots, even general meetings, but there's no response from the rest of the lot owners. And you need special resolutions to make things happen, most especially when it comes to funding. A situation like that, supported by with supporting documents available, in my view, would be sufficient reason for a lot owner or even a strata manager to run to VCAT, get an order for an administrator to deal with that issue alone. So specific issues. Administrators deal with specific issues where the owners corporation is no longer capable of passing certain resolutions because they have proven it through history. But that does not mean that there's no longer a strata manager, because what's going to happen to the daily operation? That also does not mean that the committee will cease to operate, because appointment of administrators by VCAT is taken quite seriously, and they don't just, quickly grant that decision. And the decision and the powers given to the administrator is actually quite limited. They're very prescriptive. and usually they do not relate to daily operations of the owners corporation. And so what happens, where does your strata manager come in? The strata manager supports the administrator in the usual operation. So let's say an administrator comes into this 100 lot development, was given powers to deal with this issue, the cladding issue. Of course, the administrator needs assistance. It would be the strata manager who would help them reach out to owners and do the usual administrative work on behalf of the administrator to continuously communicate with the lot owners and also the committee. But the operations, the daily operations of the owners corporation, they do not stop. And that's where the strata manager needs to continuously function in that regard. Administrators may make all the decisions instead of the committee of the owners, but again, on prescribed matters ordered by VCAT, may only make some of the decisions, again, according to what VCAT orders them to make, what they are authorized to make according to the orders. Rules are there so that you as a committee could manage misbehaviors or misconduct of residents and visitors of the development. It has happened from time to time. And this flow chart is a brief guidance on how you could conceptualize new rules that your development may need. And usually that starts off if you notice that there are issues, misbehaviors that are reported to you by other residents or even your strata manager, and that you are looking at the model rules and they are too wide, that you need specific rules, registered rules that would fit the need of your development or your owners corporation. So let's say your issue is there's so many complaints that you've received as a committee about pets. And let's say this committee is thinking about what kind of rules should we make that relates to management of pets? Should the rule mention a weight limit of the pet? And let's say the committee says yes. So, okay, so if we want to create a rule that relates to the weight of the animal, should we weigh it on day one of their arrival in the development? And if this particular committee says yes, really, who's going to do it? Are we going to take turns as committee members? Are we going to pay the strata manager to weigh? Are we going to pay the building manager to weigh the animal on day one? And if the answer is no, then what if the rule addresses the animal or the owner's behavior? Yes, okay, that's a good rule. It focuses on the behavior, managing the behavior. But whatever that rule is that relates to the pets, it must have the following elements. It must be objective, it must be specific, and that the owners corporation has the legal right to regulate that particular matter. If you want to know more about the categories that the owners corporation could make in relation to rules, look at it in Schedule 1 of the Owners Corporations Act. That's at the back of the Owners Corporation, and it has categories that you could make in respect of rules, specific needs that you may think the model rules don't really address, and you need to make it specific that would fit your development. But of course, it's not about not just reacting, but also being proactive. I'll get to you, Mark, shortly. It's important that as a committee, you could have a discussion and consider educating everyone first rather than reacting. You could consider, rather than the committee being known to just issue letters when someone complains about someone's behavior or misbehavior or misconduct, there's a list, if you recall what Carol said, various ways to disseminate information. Remind the residents, visitors about certain rules, put signages. And so it's important to educate everyone first so that they don't feel that they're being targeted when you issue a notice if someone complains. Let's say too much noise. And remind them why rules are important. Why are rules important? So that you can all enjoy your development. There's a reason why you're putting your time. You volunteer your time here. And we commonly hear, I really love this development. I enjoy living in this community. And so that everyone lives harmoniously, and emphasize that. The reason why we need to just remind everyone about the rules is so that we can all enjoy our development. And seek to understand why they are not complying. So this is when it comes to enforcement. Complaints are issued and someone complains about someone's misbehavior or misconduct. As a committee, first understand why they're misbehaving rather than just giving immediate instructions to issue a breach notice or final breach notice. And then determine whether a dispute resolution meeting is necessary. That's after you receive sufficient evidence that it's worth the owner's corporation to enforce the rules. If it's not enough, you can always give back the complaint to the complainant and say, if you would like us to consider this further, please provide sufficient evidence. At this time, we don't have sufficient evidence. So those are the different steps. There's a list. You might have seen at the beginning, there was a list of PDF documents in the slides. They're actually the pack that is going to be given to you, and have a look at the different policies that you could use. So there's rules enforcement policy, debt collection policy. They're very good for you to look at. You could consider them, make amendments that fit your development, and then fit them in, pass a resolution that that's the policy that you would follow. Give that to your manager so that your manager will also understand, because they're your hands, so that they understand what role they would be taking in when it comes to, for example, rules enforcement or debt collection. So keep that in mind. And that way you also avoid allegations that the committee is targeting certain people. I hear, how come you're only issuing me a breach notice about, I saw this about the decorations I put on a balcony, but I see 2 to 3 neighbors along the same street put one up. I found out you haven't issued a breach notice against them. How come are you targeting me? So it's important for, as a committee, how will you educate everyone about the rules and the policy? If you don't have one yet, have a look at that. Mark, you've got a question.
Yeah, look, one thing I've been asked by 3 different owners corporations I deal with is how do we fine a lot owner for doing the wrong thing over and over? And I say to them, you can't fine a lot owner. We've got video and proving all the things they do, like literally tipping coffee out on the carpet, things like that. So what I say to them is, I said, we'll get the evidence, and what we can do is we can probably charge them and tell me if I'm wrong, and tell everyone here, we talk about charging them a fee to retrieve the security footage. We've got to be careful if you're doing it in-house, because how do you do that, right? And we manage a fair bit of ourselves as a committee member. And then the other thing we say is, well, when we've got the evidence, we can charge them for cleaning costs. But like anything, people want to be able to say, here's a set of rules. If you do this, you're going to be fined. And we can't actually put that in a rule that we can see. You can't put a general notice out to all the residents to say, if you dirty the carpet, you'll be charged cleaning, but we can't say there'll be a security in that and there'll be X amount. It'll be dependent each time. So maybe you could comment on that, because I do have to drop off soon, unfortunately, but it's been great so far.
Yep, great. I'm glad to hear. No, you're right. Summary, you're right. You cannot say we will charge you this amount, because the ability of the owners corporation to charge is after you get VCAT orders or court orders. But say that if we incur expenses, we the owners corporation may take further action to seek this amount from you in the appropriate VCAT or jurisdiction. We hope that this is not necessary. If issued a breach, especially if it's repetitive, if they're a recalcitrant offender, it's important to keep a tab of how often they've been doing it and where it racks up. If it's a lot of expenses already incurred, the owners by the same person, the owners corporation should actually keep a tab and really consider actually taking legal action or VCAT proceedings. If it's someone who's been doing it 10 times, that's just ridiculous already. And that's actually a summary here. Not all rules are enforceable, so do have a check, get the appropriate expert advice, review the rules before any action is taken. So, and that's where it sounds like in your development, Mark, you need to consider registered rules, because it sounds like there's specific behaviors that's
I'll tell you
now.
quickly, just so everyone understands.
Sure.
During COVID, the government had lease housing rent some apartments. They rent it for more than twice the market rate, so the owners don't care if the place gets damaged. And it's not them particularly; it's every one of their, I'll call them clearly, drug-affected guests that come in regularly and just, it's one apartment out of 60 or out of 100. It's just a shock. And then of course we try to get them. We breach them, about 6-7 breaches. We had police break the door down twice. And once they pulled the gun out, and we've given all that evidence to the agent, real estate agent, who's taken them to VCAT, and of course they get legal aid. It's a nightmare, and they haven't been booted out. So it's a long process. My advice is collect every bit of evidence, collect every bit of footage,
Yes.
link everything to the guests, and keep a dollar value of everything, because you won't get the money back out of the bond, but
Yeah.
it gets rid of them eventually.
Yeah, Mark, if I can just reiterate that, it is a long and very stressful process. I have a building in which 2 years ago we had a situation where the building was actually set on fire and all of the residents were homeless for a week because all the power and water and everything was turned off in the building due to a similar situation to what you have just.
You're ticking the same boxes as us, but we
Yeah.
haven't had burnt the place. They've lit little fires, but
Yeah.
it's painful. It's really painful.
It's very, very stressful on all of the other residents as well. It could be described as discrimination in reverse.
Well, we've had I think it was an Airbnb person get stabbed. So they robbed him of his gear, and then they cut his face, and the police couldn't do anything because they didn't know who he was. It's mayhem, and the police aren't too interested. They raid him for drugs, but what I'm getting at is one bad apple in a fantastic residence. So I'll tell you what is a fix for everyone. We ended up putting in 40-something cameras, as in you have one camera in the hallway facing both ways, and all of a sudden you've got evidence. They could still break a camera, but you'll catch that. The advantage is when the next lot of tenants come to move in, they look and they see the camera, they might rent somewhere else. We're getting that vibe already.
So it wouldn't be in Richmond, would it, Mark?
No, it's CBD, very close.
Yes.
I won't name Civium as being the previous caretaker, but take a guess. Okay. I'm going to drop off. Thank you very much. It's been fantastic. Sorry I can't stay.
Thanks.
That's okay. Thanks, Mark.
Take care, bye.
So it's all about education. Make sure when the committee enforces the rules, it's based on facts. Evidence is presented to you. If you don't have enough evidence, knock it back. Ask them for more. If they want to push with their complaint, be reasonable with your decisions. If it's only been an offense once, but if it's a repetition of the same offense, then consider issuing a breach notice. Because, for example, if party and the noise complaint was only occurred once, you need to pull back and reconsider as to whether it's sufficient for you to make a decision to take further action by issuing a breach notice, final breach notices. Make sure that serve proper notices. I know it's your strata manager, but the committee needs to be involved in understanding that that's, as long as that's compliant, the breach notice, final breach notice. And where necessary, especially if the committee is considering taking legal action, get the appropriate legal advice before taking that action. Rule enforcement policy is the tip. Have a look at the sample that we sent, that SCAV has sent, and to make sure you can start off if you don't have a rule enforcement policy in place. Here's another thing that the committee needs to understand. Are you about compliance? Do you have your committee? Do you have an OH&S policy? Is review of safety an agenda of your committee? Do you know who completes the annual assessment, annual essential services report for your building? If you have a pool, is your pool registered? Do you know that? Is your pool healthy and tested? A checklist of this. But what's important is you should not, as a committee, confuse your statutory duties with your financial obligation, the responsibility. You must make sure that the repair and maintain of essential services management do not consider calling too many quotes from different suppliers. Make sure where you're asking for quotes, it's reasonable amount of quotes if you want to be satisfied that you are getting value for your money. Also ask for this way you would have done your due diligence, and the repair and replacement of essential service management can happen without putting anyone's life at risk. So keep that in mind when it comes to, because the owners corporation is responsible for what occurs on common property. Risk management is another part. And you can see here a table that you could start off with, identifying the different types of risks that your owners corporation could be open to. Again, you see on the tip there, there is a policy for each risk that's been identified. Have a review of that and see how you could start off a risk management policy, and also guide you in the table. And I'll pick one here. So for example, when it comes to governance, financial risks meaning making sure avoiding the owners corporation having financial issues and avoiding the risk of insolvency or fraud. What are the different types of controls that you have put in place when it comes to financial risks? Your debt collection, is that in line? To make sure that all the levies are collected so that the budget and the expenses that's been forecasted are paid on time. That's one. What about your insurance? Is your insurance covering or has protection in respect of your finances? Another one is, for example, strategic risks on the bottom. Loss of property value would be the risk. What is your media policy when it comes to the loss of your property value? So it's important that you consider what are the risks that your development is open up to, understand and identify what are the different ways that you're actually mitigating the risks. And insurance kicks in. So insurance, how much do you know about your strata insurance? Do you know what to do in the event of a public liability claim? Understanding the process is important for as a committee. What level of office bearers liability insurance do you have? Or actually, I should ask, do you have one? So that's protection for you as a committee member in the event that someone decides to include your personal names in a legal proceeding. Are you protected by your strata insurance? So have a look at that. Do you know the consequences of not disclosing events to the insurer? They could pull out. They could just refuse to insure you. Do you have all your risks covered? And keep in mind, there are two key components that the Owners Corporations Act requires to be insured. Replacement of the building, that's required by the Act, and legal or public liability, that's third-party claim. Third-party claims, so any harm to persons or damage to property whilst on common property, those are covered by the legal liability insurance. 20 million is what's required by the Owners Corporations Act. Now have a look at your policy, the different coverage that it includes, and consider these are discretionary policies depending on the features and the characteristics of your development. Machinery breakdown is one, common contents, if you have any, let's say expensive appliances or furniture. Flood, office bearers insurance, like what I mentioned, and fidelity cover is the one that protects your funds in case it's because of fraudulent activities. So have a look at that. As a committee, you need to be aware that technically, even though the strata manager is the custodian, they hold it, it's the committee's responsibility to manage the records of the Owners Corporation. So what's included in the strata records? What's included in the strata records would be email and phone numbers, and any lot owner has a right to inspect the records and request for a copy at a fee according to the Owners Corporation regulations. The custodian of that is your manager. However, you're the one who decides on what goes in that, and therefore you should have an understanding of what that should include. Got 3 questions. So we'll start on the bottom. What is a strata plan or plan of subdivision? Remember, that the plan of subdivision defines the boundaries and identifies what's private and what is common property. What is the purpose of the rules? It governs the behavior of people living in or visiting your development. And 3 policies that your owner's corporation could take out. One is voluntary workers. This is if you have a common garden. This is an example, and you have, as a committee, have approved that any resident can plant on a common garden. So to protect the owner's corporation, just consider putting in voluntary workers cover. Common contents and fidelity are 2 other types of discretionary covers that you could include. And I'm gonna move on to governance. Do you have any questions before I move on in respect of business? Because I know that I can tell, I can't see it, but I'm absolutely sure Carol is doing an excellent job answering the questions.
Yes, Rochelle.
Great. Thanks. Thank you. I'll move on and deal with the with the first half of governance. So governance is a good governance is what we've been discussing a lot tonight. What we've been sharing is actually best practices for you as a committee. And this includes remembering your purpose as a committee. What is really your purpose? And as your purpose again is oversight. Your purpose is you're the engine of the owners corporation who makes decisions on daily operations. So we'll be covering policies, which I've touched on already. I've touched on and made a number of suggestions. Planning your meetings. We'll also be discussing money management. So let's have a look. So you can see here in respect of policy making, there are really 3 parts that you need to keep in mind as a committee. You have the community. You also you need to deal with the community and the enjoyment of those who are entitled to use the community, the strata community, common property. You also have the management aspect, managing the affairs of the owners corporation. And then you've got the governance. So some examples of the community is you considering policies relating to social media, security, depending on what your development needs are. Move in, move out. If there's a lot of tenants that moves in and out of your development, if it's a stage development, if there's still some lots that are not yet developed. Are you welcoming new residents in the community? How will you be managing the communication with the residents and lot owners? So consider whether there's particular policies that you need. And I guess what I'm not saying start with everything. Start with what you need most first that you should be working on so that you could actually enjoy being in the committee. Management. Investment of funds. If you have decided to raise certain funds that would be used for investment, put it away so that there could be a big project to improve your community. Debt management, invoice approval, put in a policy so that it's you as a committee could make a decision and give official and standard instructions to your strata manager when it comes to approving invoices and paying of invoices. Have you considered a policy in relation to waiving a penalty interest, because you have the power to make that decision? So you could consider making a policy in that regard. That's a way also to encourage lot owners to pay on time. Procurement, especially with significant works, how to manage tender of contractors and service providers. How would you be handling that? What are the procedures, especially with large projects that you want to put in place? And reporting. What types of reporting do you require from your strata manager? What expectations? And that way they can have a conversation with you as well on whenever you meet. And there's certain standards that you put in place on the types of reporting that are presented to you at your committee meetings. The other aspect is governance. How you hold your meetings, standing orders, certain things that you need to address in each and every single committee meeting. Rules compliance, bullying and harassment policy, OH&S matters, emergencies, and risk management. So there's different types. And again, I do refer you to the pack But one thing I do need to address as a committee, this is all in the Owners Corporations Act. Committees have a duty, committee members have a duty to act honestly and in good faith, exercise due care and diligence, and that's why all these things that we are sharing, all these steps, that's if they're acted upon, it's so as you could exercise due care and diligence, not make improper use of your position as a committee member to gain directly or indirectly an advantage for yourself or for any other persons. Another duty is to report to the Owners Corporation at each AGM what has occurred in the past 12 to 15 months so that they're aware of the hard work that your committee has been making. And of course, when you make decisions, it's all about making good faith. Good faith requires a party not to undermine others' interest. And good faith is linked to acting reasonably, but it could include also cooperation, reasonableness, loyalty meaning loyalty to the lot owners, and of course, honesty. All those things are important when you are making a decision on the daily operations of the Owners Corporation. So there's a suggestion. Purpose, authority, scope, specification, PASS, PASS. These are 4 key elements when it comes to policy writing. So the policy must have a purpose. What is the point of the policy? What is it trying to achieve? Does the committee have a right to create that policy? Do you have the power under the act or laws? Define the scope. Who and when is it applicable? And specify, set out the process that needs to be followed step by step. So that way, again, if you are working with your manager and you are expecting your manager or any other parties or your building manager to act on behalf of, based on the policy, it's specified. And there are also strategic planning matters that you need to consider. How will having a strategic plan help guide the committee's activities? So one thing I do want to emphasize here is, for example, on do you have, let's say, a financial plan? Do you have a disaster plan? An emergency incident plan? Do you have plans like that? So those of you who are holding, let's say, what do you call that? Fire drills, for example. Are there certain plans that are created when it comes to emergencies? That way, you as a committee could be prepared, because you will be the first collective that will be looked upon when it comes to certain matters that are not expected. Do consider them, put them in place, so that at least that way, when certain incidences that you don't really plan happens and you're surprised by them, at least you've got a plan in place, a policy in place, so that you can deal with the incident that you were not expecting. I'm going to be handing this because it is actually more appropriate, and I'm absolutely sure that Carol has a lot more on committee meetings and the rest of the session on governance.
Fantastic. Thanks, Rochelle. Thank you very, very much for a really informative session. I think I have responded to the majority of queries in the inbox. It's filling up the chat box. However, if you could just keep an eye on it, please, so that we can have most of the responses done as we get to the end of this session. I did mention earlier in the piece that convening a committee meeting is a 3-day notice. Everybody these days has a very busy lifestyle and very busy time frame schedules. So sit down, have a chat with your OC manager and ask them to try and get the documentation to you at least 7 days, if not 10 days out from your committee meeting, so that all of your committee in their busy lives have time to look at the documentation, have time to understand what it's asking of them, so that they can so that you can just come to the meeting and have a clear program of just discussing the issues for 5 or 10 minutes or so, and then voting on it, rather than having to pull apart or segregate every document that you've received, which takes up all of your meeting time and no decisions get made. So please work with your strata managers in an endeavour to improve the flow of information between yourselves as committee members and themselves as the strata manager. As a committee meeting, in contrast to an AGM or a special general meeting, must have a quorum. A committee meeting cannot proceed if there is not a quorum. A quorum is 50% of your members. So if you have 5 members, you must have at least 3 present to conduct a meeting and make valid decisions on behalf of the committee. If your members are going to be away, if you're aware that any of your members are going to be away and they are offering a proxy, the rules state clearly now that a committee member can only provide a proxy to another committee member. They cannot give their proxy to someone outside of the committee circle. It must go to a committee member. The reason for that logic is that you give the proxy to someone else who knows absolutely nothing about the committee business. They have no idea what they're voting on or anything else. They have no history. So unless the proxy has been given to another committee member, it's invalid. The minutes must confirm what actions were taken at the committee meeting, not necessarily what was said, because it does not need to be war and peace. It just needs to be a resolution or a motion committing to an action. And maybe there might be some notes to identify that action, but all of the conversations do not need to be, it does not need to be a he said, she said. The meetings really need to confirm the actions that the committee are going to take. So if you're voting outside of the committee meeting, you have a project in play that needs decisions, then you need to ask your strata manager, or in some cases, my committees that I work with actually conduct the ballots. I give them the resolutions or motions, and they conduct the ballots and then come back to me with the results on the decisions that are required to be made outside of a committee meeting, so that you keep the project moving. It's all about keeping this work flowing, so that you can get your work done, that the strata manager can get all of the pieces of paper or emails that come across their desk attended to as well. So you may, as I said, either ask your strata manager to conduct the ballot for you. Now, you need to check with your strata manager whether they will be charging you under the 2.2 section of your contract to conduct a ballot for you. Now, the results of the ballot, there must be a minimum. If it's an ordinary resolution, the committee cannot make special resolutions or unanimous resolutions anyway, but an ordinary resolution requires 50% of the committee, 3 out of 5, if there is 5 on the committee, to at least vote in favour. We've mentioned that they must be a quorum who have voted for within the ballot, and there should be a minute from the OC manager confirming that this ballot took place and this was the result. This was the outcome in your next set of minutes. Thanks, Rochelle. So, managing the manager. Set operational rules that you want to be effective and efficient. And that may mean that you sit down and you have a discussion with your manager. That this is how you would like the business of the owners corporation to be managed. That when they send out quotes, they're time framed. Yes, we as the committee agree to get back to you within this time frame so that you can keep the work moving. Both Rochelle and I have talked about that quite a bit tonight. Undertake an annual performance review. Now, this is not only, I have seen a situation where the committee decided to do a performance review of the OC manager's role. However, they did not look at themselves. You need to look at yourself at the end of a 12-month period and say, what did we agree to do within this time frame? What have we accomplished? What has the manager helped us accomplish? And if it hasn't worked, you need to sit down and work out a way that you can get it to work, because it is no different to any other job. There, you know, you need to have a set of KPIs, i.e., I want the manager to respond to correspondence within 48 or 72 hours or whatever it might be. Don't necessarily just rely on the content of your management contract with the manager. That is just a guideline of what the manager is supposed to do. It doesn't give any idea of what the committee's role is within that document. So maybe you need to give yourselves a set of KPIs, i.e. around financial management, around putting policies in place, around rule breaches, around a lot of the things that Rochelle has spoken about in the previous set component. Work with the manager for improvement. Over the years that I have been in this industry, I have seen owners corporations, and we heard a story before about how many managers a particular owners corporation has had. You need to understand that you are an employer here. Josh, I'll be with you in a minute, that you are effectively the employer here. And when you go to the market to employ a new strata manager, you should be treating it as a recruitment. You need to interview these strata managers, not just take their word for how good they are or how fabulous their management proposal is when they send it to you. You need to set up interviews. You need to talk to them. You need to get a feel for them. Will they become part of our team? Because that's what you want, is a manager that will become part of your team and that will assist you to achieve your goals. And if you just choose on price or because you've got a fancy proposal that looks good, then you possibly could end up with the wrong person managing you. Treat it like a job interview. I cannot encourage you highly enough if you are have good reason to change managers that you follow this process. If you don't have a legitimate reason for wanting to go out to the market, because it is a costly process to change managers, then you need to encourage your manager to come and sit down with you and have an open, transparent conversation. We feel that these boxes are not being ticked. Is there something that we need to do in this space, or is it something the manager needs to do in this space? So work with the managers to endeavour to improve their performance and look at your own performance as well. Josh.
Yeah, so well, I agree with everything you said about working with the manager and all that. If anyone's also going to tender or renewing a contract, I would highly advise as well to put some of those KPIs or put SLAs into the contract itself, so that like it's not because while and that's from having my personal experience with an OC manager, building manager, and a cleaning company as well. If when everything's going well, it's all good. You don't really look at the contract, but it's when issues arise. Ultimately, anything that was said in like verbally at the meeting or things like that, it doesn't matter how flashy the proposal looks, it's what's in the contract that's ultimately enforceable. And if the contract says that the OC manager doesn't have to do anything and doesn't have to oblige by any of the obligations or whatever, like, well, that's the contract you signed. And so when reviewing the contract, I would say actually probably review the contract, but also if you're going for tender, if you're renewing, put SLAs in there, say that like there will be a financial penalty if the OC manager consistently doesn't reply within X number of business days to emails, for example, just to have that in place and have that upfront so
Yes,
it is enforceable.
That's excellent advice, Josh. And always, if you are not an experienced committee at looking at contracts and understanding the content in contracts, spend a few dollars and go sit down with a lawyer and get them to walk you through the contract so that you understand exactly what you're being asked to sign off. And do you want any special clauses or conditions in it, as Josh mentioned? So if you're not familiar with contracts, the current SCA contract for managers that are members of SCA and use the SCA contract has just been revised. And it's significantly different in its setup and set out to the previous one. So the next time you come, whenever your contract expires, you will receive this new edition of the SCA contract. Do not sign it without reading it and understanding it. Okay, thanks, Rochelle. Investments. Both Rochelle and myself have talked about the fact that the OC committee are accountable for the OC funds. So you need to think about how often do you receive a financial report from your strata manager? Is it only at the annual general meeting, or do you get a financial report at every committee meeting? Are the financials reviewed at every committee meeting so that you understand what your cash on hand is, what your liabilities are, and what your net assets are, whether you have the funds to get you through the rest of the year if you're only halfway through the year. So you need to be across all of these things. I mentioned earlier that as a committee, you should be having prior to your new financial year commencing, having a budget meeting with your strata manager so that you can sit down and work through the expenditure for the previous year and work out what you need going forward. Thanks, Rochelle. Okay, so what is the main role of the strata community? Good governance. So this is about the committee's role here. To provide essential services, that's all services to the building, in an ethical, professional manner that will lead to effectiveness and efficiency. And both Rochelle and I have shared with you tonight many ideas, and I do suggest that you start looking at policies to help make your roles easier. If you have policies in place, your owner's corporation manager knows about those policies. They don't have to keep coming back to you to ask for permission to do this or that, or get how many quotes do I get? 3, 4, 2, 1, none. They can just move forward. It creates efficiencies. Yes, there is a workload up front for the committee to put these policies in place. But once they are in place, and just an example, I have worked with a committee over the other side of town. They have a full portfolio of policies that Owners Corporation, the chair of the committee, chaired all of the committee meetings. The manager's role ultimately was just to take the minutes, provide a copy of the minutes to the committee, because they had procurement policies in place where if the building manager needed to get quotes for work, he knew exactly what to do. They had investment policies in place. Because they have almost $1 million in their maintenance, outside of their maintenance fund, invested to support their maintenance fund. The chair of the committee was so good at his job that he used to chair the annual general meeting each year as well. The strata manager was basically a secretary to this group because they were so well organised and supported by policies. How many days' notice? We've discussed 3 business days, but I think we all understand that that is nowhere near enough. And Rochelle mentioned long-term maintenance plans. What funds do you have in your long-term maintenance plan? And if you have an emergency during the year, this is just doing a bit of a reverse back to budgets. When you put your budgets together, do you allow for a contingency in those budgets, or do you just squeeze them until the life is squeezed out of them and there is no spare funds for anything? You have an emergency. That emergency is, let's say it's $60,000, $80,000, $100,000 to rectify the works. Think about in this circumstance, think about your personal budget. What happens when your car motor blows up, or you blow a couple of tires, or unexpected expenses occur? You get stressed, frustrated. Well, all of your owners feel exactly the same way when a special levy is dropped on them without any notice. They feel exactly the same way that you do, They are become emotionally distressed. They may not even have the funds. We don't know or understand the financial flexibility of all of the people in our owners' corporations. We need to be conscious that the majority of them will have a budget. They'll have mortgages that they're probably paying. They will have other expenditure that they have, and they may not have too much flexibility in their cash flow. And all of a sudden, they've had a $5,000 or $7,000 or $11,000 special levy dropped in their letterbox. So when you are putting your budgets together, put contingencies into them to cover off for the emergencies. I can't encourage you enough to do that. Yes, you'll have the naysayers saying, no, we just want this, we just want it at this. But when you have an emergency and there is a huge special levy to be raised, it will seriously affect people. And the legislation quite clearly states, so this is what you're battling with as well, that you cannot commence these projects until you collect all of the funds. Now, if there are 4 or 5 people who do not have the flexibility to make the payment on this special levy, then how on earth are you as the committee ever going to get the work done? It's just like banging heads in an argument. You need to have a contingency in your budget. You also need to allow for arrears. You need to work with your strata manager to make sure that your arrears are no more than 2.5% of your annual budget. If it's any higher than that, then you're in trouble. It means you will not have the funds to renew your insurance or do the things that you need to do for the balance of the year. And within your smaller OCs, the 8s and 10s, if you have 2 people not paying their fees and levies appropriately, then you will run out of money at about the 9-month period. So you need to take all of these things into account. You need to understand that insurance costs, and this is the major issue in all budgets right now, that insurance costs in the last 2 years have increased up to 35% annually. So you need to be building this information into your budget. And as a committee, you need to understand and research what you actually need to put in the budget. It's a good idea to chat with your strata manager and work out how much, particularly very large buildings, how much per week it costs to run the building. This building I was talking about before with the committee, it cost $10,000 a week to run this building. They had 6 lifts in the building, all of the essential services, the electricity costs, the water costs, the all of the services within the building. It cost $10,000 a week to run this building. And the committee, with that information in mind, was able to set really, really great budgets for this owners corporation going forward. So please keep all of that in mind. Just think about, if you need to raise a special levy, think about how you would feel if someone took a chunk out of your budget without it being planned for. Thanks, Rochelle. these are the committee resources, which will all be in the pack that you will receive at the during this training. I think Sam has already put it up. So there's a committee post-training pack, a committee training slide deck, committee induction pack sample, the purpose of the committee, a sample of a code of conduct, sample of an OC committee charter. So all of the things we've talked about. There's a list of all of the policies that committees can put in place within their owners corporation, a sample communication policy, sample debt collection policy, a sample OC bullying and harassment policy, procurement policy, waiver of penalty interest. So you can see here all of these things, all of these policies will contribute to the efficient running of your owners corporation. Contract of appointment consumer guide. There's an example of a management plan for those owners corporations who would like to put a management plan together. Risk assessment, there's an example of that. Top 10 rules for tenants. So rather than just giving them a sheet with rules on it, you might like to address it in a different way. There is also some information about short-term letting, which for those of you who are not aware, the Victorian government has changed the legislation on Airbnb and short-term letting now. They have put a 7% tax on all earnings from short-term letting. So that will change that space over a period of time. There is an example of a VCAT case. We encourage you to read that. There's committee training handouts and a document from the South Bank. There's an owners network group at South Bank and their emergency preparedness. And that is really, really important. I did mention that I had a building that had a fire in it. This fire was 11:30 at night. We had to find accommodation. Some residents were able to go off to family. Others we had to find accommodation for that period of time. And if you're not prepared for this, it's very stressful. You need to, first of all, in a situation like this, know that everybody is out of the building and safe. That is the number one priority. Then how do we house them? What do we do with them? You know, you need to approach your local councils and talk to them about what emergency planning they may have in place. I was involved with another building that had a fire, and I was aware that the council provided 3 nights emergency accommodation in these situations for these people, because we had a whole wing of this owners corporation that they could not go back into their apartments due to water damage. We were able to accommodate all those people for 3 days, thankfully, because the council provided a space for them. That allowed us to contact property managers, owners where there were tenants and say to them, you will need to find new accommodation for your tenants for the next 12 weeks until the repairs for this building are completed. So it allowed us as the managers to put a whole heap of processes in place without running around not knowing which space we needed to step into or where our assistance was needed first, because there was a plan in place. So this is really important. We think it will never happen to us, but we've just heard an example tonight of what does happen in some of these buildings, and you committees, as a committee member, you need to be prepared. I think that's it for me, Rochelle. And let's open up to see if there are any questions from anyone before we close the session off. So we'll have an open forum now. Darren.
One question that we're constantly trying to deal with is maintenance plans. We've obviously got a maintenance plan in our development, and we're looking at the relevant sections in the Act, and it says funds can only be spent in accordance with the maintenance plan. We're being told that the maintenance plan is merely a guide.
Well, you could, it depends entirely on whether the maintenance plan, and Rochelle's probably better to respond to this from a legal point of view, more qualified than what I am, but it depends a lot, Darren, on whether the plan has been adopted or not. Correct, Michelle?
Yes. Yes.
Yep.
So the minutes of the AGM says it was approved and adopted.
Yep.
Yeah, the committee really has the power to amend the maintenance plan on needs basis, but if the committee decides to amend the maintenance plan, it should justify it in case lot owners address questions as to why were we presented this and your committee decided to do something else. And that's where the transparency and honesty is. But the committee has one of those powers to amend the maintenance plan.
Yeah. And I guess what we're really grappling with at the moment with committee decisions, and trying to get, I guess, clear advice as to whether we can or not do it.
Look, sometimes it's good. I know that it's a cost to the owners corporation, but sometimes it's really good just to reach out and get the right advice, whether it's legal advice, whether it's a building surveyor, whether it's financial advice. Get permission to spend the extra dollars and get the extra advice. At the end of the day, it will enhance your knowledge and your skill, and you will be able to make those decisions going forward, and you'll also be able to help assist any new committee members that come on board. Because none of us are experts at everything. We all tend to have a specialist field, and it's really good for committees to work together as a team and get the expert advice that they need to make the appropriate decisions, because you have responsibility whether you've got 10 owners or 200 owners. They are relying on you to make appropriate decisions for them.
And the word amend, Rochelle, amend the maintenance plan. The committee can amend it. That would mean it'd have to adjust all the figures, does it? Or what does amend actually mean?
Items, both amend, you revise, you change it, items and expenses.
Yeah.
But the Act does say that expenses must be in accordance with the maintenance. You have a plan, items to spend. This is the estimated budget. The committee could revise that, but record it. But I want to add, justify it as well.
Yeah, because the issue we find is bringing forward expenditure. Yeah. So, for instance, gym equipment in the maintenance plan is not due to be replaced until 2027, but the committee decided to replace it in 2024, 3 years earlier. And the maintenance plan hasn't been changed.
Right. The committee is empowered to a certain extent. These are all general advice because
yes,
I don't have information about your owners corporation. I must say that these are all general, but generally the committee has the power to make amendments. Record that must be supported by a resolution of the committee. So you can't just have a phone conversation and random emails. It needs to be minuted, a resolution recorded, attach the details of the amendment so that in the event that an owner addresses at an AGM, wait a minute, why did you guys bring it forward, those expenses? It's all there.
Yes.
It's all there. Yeah.
Yep. Because it obviously has further financial consequences in the future.
Yes.
It does. Correct.
Yes.
Thank you.
Excellent. Any further questions?
I couldn't answer, unfortunately, Carol, the questions addressed, but I hope that's because I was sharing the screen and I can't interfere. But I hope everyone was given an opportunity to be heard or we've addressed most of the matters that you wanted to address.
I guess one question I have is any advice for committee members who have an OC manager that isn't complying? So, for example, paying invoices that the committee has not authorized, or withholding records, for example, like asking, can I have records, and the OC manager specifically said, no, you cannot?
I like to use a cattle prod.
Thanks, Sam.
Well, I mean, in this case, they are an SCA member, just to be clear as well. So like,
okay. The Owners Corporation manager is obliged to provide the records when they're asked, as much as they may dispute it and claim privacy and claim all sorts of other things. The legislation clearly states that they are required to provide the information to you if you wish to do it. Can I ask a question? Do you have an owner's portal or my community portal?
no, there was not at the time.
Okay, if you have the best way to, if you have a portal, just check whether they have introduced it or not. You can nominate, and this is what I've done with all of my committees, nominate 2 members of the committee who can access the portal and see all of the invoices that are listed for payment that week for your Owners Corporation. If your Owners Corporation pay on a weekly basis, that generally the one that I'm working with at the moment, the invoices are all loaded by Wednesday night. All of the committees have until Wednesday lunchtime Thursday lunchtime, to review and tick off the invoices as authorised. This way your committee gets to authorise all of the invoices, and I, as the manager, I don't touch them. All I do is get them loaded in. The committees approve them all. So it's worthwhile investigating whether a process, I do know that in some cases it's a manual process, which is cumbersome, invoices get lost, etc., etc. But see if there is some technology that your Owners Corporation manager has that you can use to streamline the process for you.
I guess my point there would be that if the OC manager is already paying invoices that they shouldn't be, in contradiction to the committee's resolutions, I don't think you can go and ask the OC manager to then, pretty please, can you implement this whole system that would prevent you from paying yourself still like that.
I guess,
so like,
I guess your challenge is then that you need to sit down and have a conversation with this Owners Corporation manager and ask them why they are paying invoices.
To be clear, in my specific case, they were terminated in the end.
Oh, right.
But it was a $35,000 legal battle that led to that. So I'm just wanting to ask, like, for other committee members, not myself specifically, like, what steps can they be in preparation for that, for example, to prevent excessive legal battle? Like, for example, would SCA, for example, make that a requirement that all SCA members have this feature available?
You could actually negotiate that. There's some comments about the contract of appointment previously. When you're negotiating a contract of appointment with whoever your manager is, there is a valid space for amendments. And if you want the committee to have the authority to approve the invoices negotiated at that time and get it written into the contract of appointment, that and I guess I will subtly use the word rogue managers who take on this responsibility and believe that it's solely their responsibility. It prevents that occurring, and the committee have total control in those circumstances over invoices that are being paid. Okay, hope that helps. Great. Any other questions from anybody before we close off for the evening?
Hi, yes, please. I have a question.
Yep.
I'm curious. The last person that just spoke, we're actually in quite a similar position at the moment where we are collecting as much documented evidence as we possibly can to terminate our current strata manager. We believe that we actually have enough documented evidence to refuse to pay the early termination fee. And my question is, if they decide to take us to VCAT to challenge us paying that early termination fee, if we have sufficient documented evidence to prove their incompetence, which we believe we do, I'm just wondering, in your experience, how often do VCAT find in favour of that early termination fee not being paid if documented evidence does support their incompetence?
Rochelle, over to you.
Unfortunately, I'm going to give you a typical answer of a lawyer. It depends. It depends on the evidence. It depends on how the strata manager will defend or run the case if they're the applicant. It depends on who the decision maker is. But what I could suggest is stack up all the evidences because that's what's really important to strengthen the case of the owners corporation in respect of defending itself. That said, the owners corporation should consider before it decides to defend anything in legal proceedings that it should make a decision, get the appropriate expert advice in respect of how far they want to take it. I always say that when it comes to litigation, and because litigation can just blow up, and I mean costs. Where there's a sit-down opportunity, do grab that opportunity. If it's on principle, you want to fight on, you meaning the owners corporation wants to fight on principle, it needs to prepare to spend. And that's what I say to any client. If it's about principle, it's going to cost. So that's something that the committee, I trust that helps the committee decide how far it wants to take that matter.
Yep, sure. Thank you. And one other thing I just wanted to ask as well was whether anybody else saw the Four Corners episode called The Strata Trap, and just people's thoughts on that, because I personally found that very interesting. And we've actually just saved our owners corporation $10,000 in commissions and administration fees by going through Strata Fair to get our most recent insurance policy. I just thought that was worth sharing as well.
Look, it certainly is. And both Rochelle and myself and Julie, if she was here, would encourage you all to do your homework. I think everybody knows and understands that in every industry, regardless of what it is, there are good apples and there are bad apples. Now, we all know that the bad apples are newsworthy and everybody gets tarred with the same brush. So it's about you as a committee, as Rochelle and I have both mentioned all night. Do your homework. Carry out your due diligence before you make any appointments or ask anybody to do anything, so that you make sure you are transacting the business of the owners corporation in a safe space. Darren, you've got your hand up again.
Sorry, I guess
That's
just
okay.
an observation I would also make for Amy is your OC manager a member of the SCA? Because I guess SCA has its own complaint mechanism. So if you're not happy with your OC manager, there is a way to do complaints.
Yes, I believe they are. One of the JPEG attachments that comes through with each of their emails does. I think they are a member of the SCA. Look, they were a developer appointed strata manager. They've been in place for a significant number of years. Long story very short, we're a newly elected committee this year because the way things have been run for a very long time have been very unethical, and where we are essentially trying to right the wrongs that have been in place for a significant amount of time, and we're reaching out for expert advice to actually help us in replacing them, actually. So, but thank you, Rochelle, for the additional advice this evening. That was helpful.
And it might help just to reach out to SCA as well, Amy, through their dispute process. They may be able to assist you and share extra information with you throughout the process, because it is not an easy process when you find yourself in this situation. But it sounds as though, as a new committee, you're doing your due diligence and your homework, and we applaud you for that. That is excellent. That
we're certainly trying to. It's been for somebody who also works full time. This has felt like a full-time job at times, and extremely stressful and overwhelming at times. But we're getting there. You know, slowly, catchy monkey. We're getting there.
Just think about all of the extra knowledge and new skills that you will have at the end of this, Amy.
Yes, I jokingly said to my secretary the other week, who's also a part of this Zoom, I said we should register and start our own strata management company.
That's not as easy as what it looks, actually. It's a very difficult, very complex job, but it's an enjoyable space to work in.
Carol, can I jump in?
Yes.
I want to just make sure that everybody can promote the next training, this very same training. We're going to do it again in December. We do it 4 times a year. The link is in the chat box. If you want to register, please share that like hotcakes with everyone you know who lives in an apartment who would love this training, because SCA wants to empower OCs as much as we are mostly for strata management companies, because it's a membership organization and we don't have huge amounts of resources for the general public. This is a small token that we can do 4 times a year. Please share it. It's free. We would love to get more and more people the knowledge that you've received tonight. Carol.
Yeah. Fantastic, Sam. Yes, and we as members of this community, both Rochelle, myself and Julie, are very heavily into education in this space. We want our committees and owners to have the knowledge to be able to make really good decisions for their communities. And the best way to get that is to come join us in these seminars, because it will help you make good decisions. It will help you understand when you need to reach out to the experts to get extra information. If you need to call SCA, Sam will refer you either to Rochelle or Julie or myself. If you want to discuss something privately, we're always happy to do that, to help out people. I do a lot of consulting in this industry, and your problems are not unique, believe me. Jane, thank you for putting your hand up.
Just to finish that, then go to Jade. Tomorrow, I'll be emailing everybody who registered this with Carol's contact details, Rochelle's contact details, so that you can stay in touch. Jade.
Okay, thank you.
Yeah, I just wanted to add that I've been on a committee for, I don't know, something like 6 years, and I have another committee member or 2 on this call as well. And I must say, it took us a very long time to realise that this training was available. And I'm just thinking that with your contacts in with the strata managers, even though, Sam, you do a good job in promoting these sort of things through LinkedIn and various places, I think it really needs to be sort of put upon the strata managers the benefits of having well-trained committee, because we were sort of at a loss. So we didn't know what we were doing wrong as a committee. And being on this training, I think, has really helped us see what our obligations were, because quite often it's very easy for people to say, oh, that's all up to the manager. The manager does that. And to be on this training and to see what responsibilities that we have as a committee has been fantastic. And I wish I had had this training 5 years ago.
Yeah,
Then we would then set
we email.
expectations with our strata managers.
Yeah, we have about 1,200 members in Victoria, and we email them every 2 weeks with upcoming events.
Yeah.
Of course, this event gets shared to all of them so that they can then share it onto their committees and some LinkedIn and Facebook.
And they just don't see the value. It'd be good for the strata managers to encourage when they get a new committee in. Hey guys, by the way, you're on a new committee. It'd be really good to go and participate in the training.
Sometimes the committee members are reluctant to, Jane. They think they know it all because if they've got a business background, they think they can apply that to strata. And we all know that strata's a very unique beast, and the business principles don't necessarily fit around how strata is managed, because for me as a trainer, the intrinsic component here is the human beings. For me, that's you're working with human beings. It's people's, this is their life, this is their lifestyle. As I said before, you know, they are funding their lifestyle, and many of your owners who come into your owners corporation have no idea what they've bought into, because there's no prerequisite for anyone to advise them that they've bought into a strata community. So they go in there thinking that this is my home. I did this when I lived in my ordinary house on the street. I didn't have babies crying next door or people screaming and shouting at one another. I didn't have lifts going up and down. And they just simply do not adjust to the lifestyle within apartments. So, you know, there's all of these complexities which all come back to being highly emotional and highly sensitive. And in situations like that, it's very difficult to reach a consensus as to how you might go forward from that space.
Yeah, true.
Yeah. Thanks.
And I think that for the other, was it Amy who's going through a process of a change of management? I think if, you know, had we all been educated, we might have avoided a lot of change of management. And if the strata managers had been on board with that, we could have avoided that as well.
Yes, and it is about getting to know your strata manager and building a team, as I said in the beginning. And you can only build that team through communication. There's no other way to build the team and to create respect and trust other than communication.
Yeah.
Well, it is 8:30, everybody. Shall we wrap it up?
Thanks, Jane.
Thank you.
Thanks.
Thanks,
Take care. Thank you, everyone, so much for giving up your time to come and join us tonight. We really, really appreciate it. And we appreciate the opportunity to share our knowledge with you. And we hope that even one tiny bit of it will help you do your job better tomorrow.